was pretty generous. I'm willing to drop down to $500 a month.
Okay, looks like we have both parties connected, so we'll go on the record. This is Van Til versus Van Til, file number 1717089. The record should reflect that both parties are connected by Zoom. This is set for a motion today. Mr. Van Til, you filed a motion to cease spousal support, and your motion is based on the fact that Ms. Van Til remarried at the end of 2024. Is that correct?
Yes.
Okay. Ms. Van Til, is that correct?
Yes.
Okay. Are you contesting the discontinuation of the spousal support?
To an extent, I feel that I was pretty generous back in 2021 when I let him off on over $12,000 in arrearages at the time. I'm willing to drop down to $500 a month for, let's say, another 3 years.
Right out the gate, talk about confidence. She's calling herself generous while asking for 3 more years of payments after already remarrying. But here's the kicker. Remarriage usually ends spousal support. Do you think that's fair, or should generosity buy her more time?
Okay. Mr. Van Til, what's your position on that?
No, I disagree.
Okay.
I disagree.
All right. Well, you know, here's the thing. I reviewed the original judgment of divorce, and it does allow for the court to modify spousal support based on a change in circumstances. Ms. Van Til, and frankly, I'm surprised it doesn't contain the language that if you remarry, typically once a party remarries, I mean, that's a change in circumstances that warrants the cessation of payment of spousal support. And the whole idea of spousal support is that you don't have the assistance of your marital partner anymore to support you. And when you get remarried, that's no longer the case. So if really, to me, the only fact here that would be a potential issue is whether or not you were actually married or remarried, I should say. And it sounds like that's not a fact that's in dispute. So for that reason, the court finds that the spousal support should cease. And so, Mr. Van Til, you need to file something with the court that indicates that the court is granting your motion. You can use a form like you used to file your motion in this case, okay?
Okay.
But that's an important step for you to follow up on, because until I sign that order, I mean, that's what actually stops your obligation for spousal support. So it's important that you submit that as soon as possible to the clerk's office here in Gaylord.
Okay, so it's the form just like the one I sent for this hearing.
Yep, well, you can find the form in the same place. It's going to be just a blank order. And you're going to fill in there that the court is granting your motion and spousal support will stop as of February 3rd, okay?
Okay.
Ms. Van Til, did you have any questions about that?
No.
Okay. All right. Thank you. That's all for this hearing today. Both parties are free to disconnect at this time.
Yes.
All right. And Ms. Beelan, can you unmute? Are you Brittany Beelan?
Yes, I am.
Okay. All right. We're on the record now in Beelan versus Beelan, case number 2419895. We have Mr. Blumberg here by Zoom on behalf of Mr. Beelan, who's with him. We have Ms. Beelan also here by Zoom. This is set for hearing today. Mr. Blumberg, you filed a motion. Your client is asking for relief from an ex parte order that was signed by the court, requiring him to pay certain household expenses and so forth at the beginning of the case. Anything you wanted to state by way of oral argument in support of your motion today?
Well, I would just again reiterate to the court what my motion and supporting brief suggests, that the court signed an order based on information that was not accurate. I don't know if there were intentional misrepresentations made, but the net effect of those is that you signed an ex parte order requiring my client to pay certain obligations, when the reality is that when the motion that was filed, it was asserted that she was not working and that she failed to indicate to the court that she had her boyfriend living there, a roommate who was contributing financially to the obligations. Those are certainly material facts that were either omitted carelessly or intentionally. The bottom line is that I think that had the facts been properly represented to you, you would not have signed such an order. So we're asking the court at this point to rescind that order. My client has been contributing financially, and he's prepared to continue to do so. But certainly, based on the facts that you were presented, I think that ex parte order was inappropriate.
Mr. Blumberg, are there any temporary orders regarding child support in place? Just looking through the file, you might know on the top.
No, there is not.
Okay. And how much is your client contributing monthly at this point?
This is a crucial point. Judges don't just pull decisions out of thin air. They're bound by the law. Once someone remarries, the logic is simple. You got a new partner, so your ex isn't on the hook anymore. It's the legal equivalent of new team, new responsibilities.
Okay, he's paying between $150 and $200 a month.
Okay. All right, Ms. Beeland, what's your side of this?
The reason why we decided for Chauncey to pay $600 worth of mortgage, because it is on his name too, along with mine. And during that time that I'm having a hard time understanding this. The reason why we put this, because I was working at a restaurant, barely making a minimum wage, trying to have fully intent of getting my job that is now, I work full-time at Kohl's, just so he could just help pay the mortgage. That's all I was asking. And my boyfriend, he is no longer in the home, but during that time, he was helping pay all the smaller bills, helping me out with that type of stuff. And up until he recently left, he was helping me pay all my small bills, and I was paying my mortgage and trying to keep on boat on that. And I have caught up completely on my mortgage so far. It's been hard, but I've been dealing. So I was just asking for help with that. That's all.
All right. Anything in response to that, Mr. Blumberg?
Judge, I don't know that we need to go into the facts why the boyfriend is no longer there. My understanding is he's been arrested and he probably has a no contact provision. But I don't guess that that's really relevant at this point. My client is willing to continue to pay some money to assist, and certainly the kids are with him half the time. So I'm always reluctant when I see these ex parte orders, when facts are presented to the court, and you have no way of knowing whether they're accurate or truthful or not. And I understand it's always best to err on the side of caution, but I genuinely believe that had the facts been properly presented, I don't think you would have signed this order. He'll continue to pay those expenses that he's been paying.
Okay. And Mr. Blumberg, your client is on the mortgage as well, his name?
Yeah. Yes, it is.
All right. So presumably he's got just as much an interest in keeping that mortgage current as Mrs. Phelan does.
Yeah, he does. But he has the expense of another place. Again, when these parties separated, my understanding was that they had an understanding as to how the expenses were going to be shared. That wasn't reflected in any written document, unfortunately. But yes, you're right. He has a monetary interest in that property.
Give me just 1 second. I just want to.
And here's the catch. Just because a judge says support ends doesn't mean the payments stop immediately. The paperwork seals the deal. Miss a step, and you could be paying money you don't even owe. Ever wonder how many people lose out just because they skip the fine print?
All right. Is there an amount that we can put on the record here today that your client is willing to contribute per month?
Yeah, my client said he can pay $200 a month.
All right. Okay. So I think that's fair during the pendency here, given the circumstances. So Mr. Blumberg, the court is going to modify that order and have it reflect that your client is going to pay $200 per month towards the household expenses. So if you can draft an order that will reflect that and submit that to the court, and we'll go forward from there. Ms. Phelan, do you have any questions about that?
No, I appreciate any of the help I can get. So I just appreciate it. Thank you.
Mr. Blumberg, anything further on this file today?
No, Judge, thank you.
Okay, thank you. All parties are free to disconnect at this time.